Good day everyone, I am IBARRA and I will be going to discuss my first topic, which is the legal consequences of the lawyers, professional mistakes, carelessness, and negligence by Plaridel C. Jose. In canon of legal ethics, the obligation of the lawyer to the client should be with undivided fidelity with the duty not to divulge his secrets or confidences, and such duty forbids him to subsequently accept retainers or employment from the others in matter of adversely affecting any interest of the client with respect to which confidence has been reposed. The lawyers must also observe and advise his client to observe the statute law, though until a statute shall have been construed and interpreted by competent adjudication, he is free and entitled to advise as to its validity and as to what he consciously believes what to be its just meaning and its extent. But above all, a lawyer will find his highest honor and deserved reputation for fidelity and to private trust and public duty as an honest man and patriotic and loyal man. Next is lawyers' duties and responsibilities in handling court cases. A lawyer cannot and should not delegate the duty to compute the period to appeal because it concerns a question of study of law and its application, and the Supreme Court considers this aspect as a delicate matter that should not be delegated. The lawyer should comply before he should consider himself free from his professional engagement to his client. The Supreme Court laid down the guidelines to be observed in order to have a valid substitution of attorneys when it said that no substitution will be allowed unless the following requisites concur. The following is: number 1, written application for substitution; number 2, written consent of the client to the substitution; 3, written consent of the attorney to be substituted if such consent can be obtained; and last one, in case such written consent cannot be procured, there must be filed with the application for substitution proof of the service of notice of such motion in the manner required by the rules of the attorney to be substituted. The court, unless said formalities are complied with, no substitution will be permitted, and the attorney who appeared last in the cause before said application for substitution will be regarded as the attorney of record and will be held responsible for the conduct of the cause. Next is clients must suffer for their lawyers' mistakes and negligence. The client is bound by the acts, even mistakes, of his counsel in the realm of procedural technique. In the case of Collector of Internal Revenue versus Bohol Land Transportation and Company, where the counsel persistently abstained from presenting his client's evidence in view of his theory that the proceeding therein is not equivalent to a judicial action with the purview of the law, despite of the trial court's suggestion that he presents his evidence without prejudice to having that legal question determined when decided on the merits. Such an honest mistake on the counsel's part cannot be considered a ground for reopening the case. He has no doubt taken such on his own risk. Last discussion for this topic is the punitive remedies available. Unexcusable errors committed by lawyers, more than not raised as incidental matters, were passed upon with erudite liberality. At this point, it should be borne in the mind that these mistakes, omissions, or negligence of lawyers in the realm of procedural technique are not the acts of misconduct or moral irresponsibility, which are grounds for disbarment. A lawyer may also be liable for nominal damages for failure to perfect appeal on time. Supreme Court promulgated on January 9, 1973, it was unanimously recognized that one of the most important benefits sought to be achieved is an 1. Improved discipline among the members of the bar, and better and more effective discharge by the bar of its obligations, responsibilities to its members, to the courts, and to the public. That an attorney may be reprimanded, suspended, or disbarred by any following causes: These are the following causes that an attorney may be reprimanded, suspended, or disbarred. Gross incompetency in the practice of profession and violation of the ethics of the profession. The Code of Professional Responsibility of Integrated Bar, to be approved by the Supreme Court, which shall be standard ethics for the members of the Integrated Bar. For my second topic, I will be discussing the Judicial Decorum by Florimund C. Rous. Public officer who, by virtue of his office, is clothed with judicial authority. A public officer lawfully appointed to decide litigated questions in accordance with law. In its most extensive sense, the term includes all officers appointed to decide litigated questions while acting in that capacity, including justices of the peace. The term judge comprehends all kinds of judges, like judges of the Court of First Instance, which is called now Regional Trial Court, judges of the Court of Agrarian Relations, judges of the Court of Industrial Relations, and justices of the Peace Court. The words courts and judges are used synonymously, interchangeably, generally speaking. In ordinary parlance, judges are spoken as of courts, and courts are referred to when the person means the judge only. It is common for laymen, lawyers, and judges, as well as the law, to use these terms interchangeably. But there is an important distinction between the court as an entity and the person who occupies the position of judge. Courts may exist without judge. There may be a judge without a court. General behavior and conduct of judges. In the new Code of Judicial Conduct, Canon 2, Section 2, the behavior and conduct of judges must reaffirm the people's faith in the integrity of the judiciary. Justice must not merely done but also must be seen to be done. Canon 3, impartiality is essential to the proper discharge of the judicial office. In Candia versus Tagabutcha case, it applies not only to the decision itself but also the process by which the decision is made. A judge who attempts to take advantage of his position in purchasing property likely to be the subject matter of the case before him by acting as counsel and advisor to both parties is dismissed. A judge who acted as counsel and or attorney in fact of all the parties with opposing interests of parcel of land within his jurisdiction acts in pursuance of his personal self-interest. In Balya Pondo versus Quintian case, favoritism by judges becomes more odious if directed against one coming from the poor and dispossessed. More consideration should be shown to one having less in life. The second one is abuse of discretion. This manifests disregard that the basic rules and procedures constitute a great abuse of discretion. In States Prosecutors to Comilang and Lagman versus Judge Miguel Belen, the court held as an excusable abuse of the authority the trials judge obstinate disregard of basic established rule and law or procedure. Such level of ignorance is not mere error of judgment. It amounts to an evasion of positive duty or to a virtual refusal to perform a duty enjoined by law, or to act at all in contemplation of law, or in essence, grave abuse of discretion amounting to lack of jurisdiction. Needless to say, judges are expected to exhibit more than just cursory acquaintance with statutes and procedural laws. They must know the laws and apply them properly in good faith, as judicial competence requires knowledge. In Yu versus Judge Reyes Carpio case, grave abuse discretion has been defined as capricious or whimsical exercise of judgment that is patent and gross as to amount to an evasion of positive duty or virtual refusal to perform a duty enjoined by law.